Well, we're going to take you to this conversation now as Parliament's Portfolio Committee on Justice and Correctional Services has officially begun the process to impeach Judge Makhubele and Judge Mushtak. The two have been found guilty of gross misconduct in separate cases.
Now, the move to impeach them marks only the second time in the country's democratic history that such a process has reached the National Assembly, following the landmark removals of John Hlophe and Nkola Mutata in 2024. Let's talk about this with the Research and Advocacy Officer at Judges Matter Mbekezeli Benjamin. Mbekezeli, good afternoon. Thank you very much for joining us. Talk to us about what the impeachment of a judge means in South Africa and why the National Assembly is involved at all.
Good afternoon, and good afternoon to the viewers of Newzroom Afrika. Well, the impeachment of a judge is the most serious action that can be taken when a judge has committed an act of misconduct, and it is done by Parliament after a process that starts off at the Judicial Service Commission. So the Judicial Service Commission is the one that receives a complaint of misconduct. It investigates the complaint, and then it refers it to Parliament after after the JC has found the judge guilty of gross misconduct. And so the impeachment process is a form of accountability for judges, right? Judges hold a very important constitutional function in South Africa, and so they are held to the highest ethical standards. When they don't comply with those ethical standards, the consequence is a possible removal from office through the process of impeachment. And that is done by the National Assembly because it is the people's representative. So these are 400 members who are directly elected by the people of South Africa. And so they are the ones who decide whether someone should hold a high office of a judge in South Africa.
Mbekezeli, you've talked about gross misconduct, right? Now, in practical terms, what bar must be met before Parliament can remove a judge?
So gross misconduct is the most serious form of misconduct there is. There are other lesser forms, but gross misconduct is the most serious. And usually when there is an allegation of gross misconduct, so for example, when a judge has been dishonest, like in the Judge of Judge Parker, or the judge has held a dual position of being a judge and something else, like in the case of Judge Makhubele, then the Judicial Service Commission sets up what is called a Judicial Conduct Tribunal. And that tribunal investigates the allegations, and then it comes out with findings. And those findings, it submits them to the Judicial Service Commission. And here the Judicial Service Commission must sit without the members of Parliament. Ordinarily, the Judicial Service Commission sits with members of Parliament, legal practitioners, judges, and even a law professor. But when it considers the findings of the tribunal, it sits without the members of Parliament, and it sits and decides whether these findings, are they legally sound? Do they show an act of gross misconduct? And if they do, what is the possible punishment? And punishment is in the form of impeachment or removal from office through the process of impeachment. And once the JC makes that finding, it then refers it to Parliament to execute on the finding.
Mbekezeli, the Judicial Service Commission has found her guilty of both allegations, right? However, the Judicial Conduct Tribunal found her guilty of misconduct for the tender deal at PRASA, but not gross misconduct. Talk to us about then the violation of the separation of powers allegations and the triggering of Section 177 of the Constitution, and any last-ditch attempts that she has to get out of these two separate findings.
Yeah, so Nomborelo, maybe we can start off with a little bit of background of how this case against Judge Makhubele came about. So there were two allegations against her. One was that she held two positions. One was the chairperson of PRASA, the rail agency, which is a state-owned company, and the other position was that of a judge. And the law, the JSC Act, prohibits anyone from being a judge and something else. You may only be a judge. So that was the first violation that was alleged against her. The second violation was that when she was at PRASA, when she was the chairperson of PRASA, she got herself involved in a case involving a company that was accused of state capture-related corruption. And so the tribunal found her guilty of improperly interfering with the process at PRASA. And so when the tribunal was looking at both of these allegations, they found her guilty, but at different levels. For the first one of holding two positions, they found her guilty of gross misconduct, which is the one that triggers impeachment. On the second ground, they say that it was a lesser form of misconduct. It was short of impeachment. And then when the tribunal submitted its findings to the Judicial Service Commission, the commission looked at it, looked at the evidence, it looked at what the tribunal had found, and they say that the second finding of a lesser form of misconduct was incorrect. The Judicial Service Commission said on both grounds, the judge was guilty of gross misconduct, and on both grounds, the judge should be impeached. And so they referred her case to Parliament for the process of impeachment. Now, Parliament has unfortunately sat on this finding for at least the last 6 months. Now they are starting to move. And the process of Parliament is that the judge will be allowed, as a last-ditch attempt, to make submissions or arguments why she should not be removed from office through this process of impeachment. And then Parliament, the Justice Committee, will sit and consider these submissions. They'll consider the findings of the Judicial Service Commission and the evidence that was at the tribunal. And then they will recommend to the full National Assembly, so the 400 members, the Justice Committee will table the report before them, and they will make a decision. Two-thirds majority is needed to remove a judge through the process of impeachment.
Now, Mbekezeli, is it mandatory for the judge to make that submission, firstly? And secondly, I want to bring in Judge Parker into the equation right now. The JSC finding references contradictions lying under oath. For the public, why is dishonesty under oath so corrosive in a judge, and is removal the only credible remedy?
Well, let me start with the first question, Hugo, whether it's mandatory for the judge to make these arguments. It is not mandatory. It's an invitation by Parliament to say, persuade us, tell us why we should not remove you from office. And if the judge does make the submission, then the Parliament will consider it. If she chooses not to make the submission, the process still continues and Parliament will decide on her fate. Now, coming to Judge Parker, and you asked the question of why is dishonesty such a serious offense? Well, first and foremost, a judge should be, the integrity should never ever be questioned. There shouldn't be any reason to doubt a judge's honesty, a judge's integrity, a judge's commitment to the law and the Constitution. So if there is anything that will cause doubt in the judge's integrity, then that triggers the disciplinary functions of the JSC. But lying is the worst form of misconduct, or one of the worst, because that means we can never trust anything that the judge will do after that. If the judge is to lie about even the smallest of things, then we can never trust them with the bigger responsibility that they hold under our Constitution. And so in this case, Judge Parker was found guilty again on two allegations. The first allegation was that he lied about an assault. Because in 2019, he said that he was assaulted by former Judge President Hlophe at the High Court building in Cape Town. A year later, in February 2020, he said that he misremembered and he did not have a proper recollection of the facts of the assault. But by that time, he had told at least 6 other judges in the court that he had been assaulted. So for a year, everyone at the High Court in Cape Town believed that Judge Parker was assaulted by Judge Hlophe. And then a year later, he recanted that statement. And so the finding is that you either lied about the assault happening or you lied about the assault not happening. But either way, you lied. And so that was an act of gross misconduct. The second allegation was a lie by omission, in that when he applied to be a judge, he never told the Judicial Service Commission that there were issues, financial irregularities at his law practice. And so when he was appointed, these then came out. These financial irregularities came out, and by then he was under investigation by the Law Society. And so by him not disclosing that information, it was a lie by omission. And again, he was found guilty of gross misconduct, and the Judicial Service Commission referred his case to Parliament for impeachment.
Mbekezeli, just again on Judge Makhubele's case, I mean, you mentioned that Parliament has been sitting with the findings for 6 months. The investigation itself, just from the time that she was reported, has taken 7 years. Talk to us about, very quickly, the implications on the judiciary, but also on the individual during this time.
Look, the implications on the individual, I don't think in the case of Judge Makhubele, she was on suspension, on full pay. And so the delays, although were prejudicial, but they were not so bad on her. But they were on the integrity and reputation of the judiciary, because for 7 years, there was a judge who was accused of very serious things, and the process was just taking too long. And this is something that we have raised as Judges Matter, to say that there is a problem in the disciplinary system for judges, in that, number one, it is too complex. So there are multiple steps and multiple stages, which causes this long delay. But secondly, the system itself is not properly resourced. So there are not enough officials to assist in the processing of the cases. But more seriously, there are not enough judges to adjudicate these complaints. And so these are the key 3 weaknesses that make this process so slow, and which is why we see cases running for 3, 4, 5 years. And in that time, a judge is on suspension on full pay. And so what we are proposing is that these processes, number one, should be streamlined. Number two, they should be properly resourced. And number three, and this is something that Parliament is considering, there's a bill before Parliament, is to increase the number of judges who sit on the Judicial Conduct Committee to adjudicate these cases. And hopefully that will speed up some of the processes. But yes, you're quite right, Mpumelelo, it's a big problem.
Judges Matter Mbekezeli Benjamin speaking to us around the impeachment processes around Judges Nana Makubele and Judge Mushtak Parker.